Hello, everybody. We're going to reconvene very briefly so I can tell you that we are recessing subject to the call of the chair, which we anticipate will be at 2 p.m. Thank you. All right. This meeting of the Government Administration and Elections Committee is reconvened. I'll start with a remark from at least this co-chair, which is, as I said before, because, I'm sorry. All right, so sorry, this meeting is reconvened. In reference to remarks from the chairs, at least on my end as co-chair, I just wanted to say again, as I said before, that through inadvertence, the substitute language for the early voting bills was not provided to all the members until this morning. And that's why we recessed and reconvened, so that all the members would have a chance to review the language and be prepared for any questions they may have on it. And I just wanted to convey my regrets on that, this oversight, and certainly no ill intent. And that's why we took the recess. So we're glad to be back now. I will give my co-chair, Senator Flexler, the opportunity for any remarks.
Thank you, Mr. Chair. And I would just echo your sentiment. Glad to have the members here today for our first committee meeting to possibly approve bills, and I'm grateful for the patience of all the members of the committee and their willingness to review the language and be ready for today's important discussion. So thank you, Mr. Chair.
Thank you. And with that, we will move to Roman numeral number 3, which is bills and resolutions for final action. We will first move to item number 1 of that section, which is Senate Joint Resolution number 29, a resolution approving an amendment to the state constitution to allow no excuse absentee voting. And that would be a JF to the floor. I will entertain a motion to JF that item to the floor. Moved by Senator Flexler, seconded by Representative Morin-Bello. Are there any remarks? Senator Sampson.
Thank you very much, Mr. Chairman. Just before I even get started, I just want to follow up on your comments at the beginning of the meeting and say thank you very much for making that note. I would just make an observation that we really ought to consider some rule changes. The chairs of this committee are very good to work with, and they are by no means the worst offenders of the abuse of the rules, as I would put it. The rules themselves, I think, lend to some of the problems that we have. I don't know if the public is aware of this or not, but there are certain deadlines that the committees have to follow. For public hearings, for example, they've got to put out the agenda for the public hearing 5 days in advance, but you can count the 5 days, starting at Thursday night at 11:59 p.m., and then say Monday morning is your 5th day, which I don't know that that's really fair to the public who might want to be able to, submit testimony and sign up, especially when we have kind of limited the sign up portion till 3 p.m. the day before the hearing in most cases these days. So I think people have a much more limited window, although I do think it's been wonderful that people are testifying both in person and remotely. I think that's opened a lot of doors to get people's, views on different things. So I think that's wonderful. But when it comes to committee meetings, the committee posts the agenda no later than 6 p.m. the day before the meeting. And I can tell you sometimes when we have some lengthy agendas, today's only 12 items, although they're substantial items and I think very consequential ones. But we've had, committee meetings with, 50 plus items on them. And it is very difficult for the minority or anyone who's trying to track the bills to be fully up to speed, even getting them at 6 p.m. the night before, especially since you may be in another committee or hearing, or God knows what else is going on in life. So it's something that I would just wanted to make a comment about, because I really do think that it's not appropriate for to have such a short window of time for the language to be available to members and the public. And I hope that, going forward, maybe next year when we are sitting down pondering the rules vote at the beginning of session, that maybe we take into consideration that we want to provide a little more time. That said, I'll get right to Senate Joint Resolution 29, I guess, is the first item that we're going to address. And I know that the second item is House Joint number 1. And effectively, these are the exact same bill, which is the follow-up to the no excuse absentee voting constitutional amendment. And for those listening, the process that's required is that in order to make a constitutional amendment, a bill has to either pass by a 2/3 majority. Is it 2/3 or 3/4? Three-quarters majority in both chambers in one session, in which case it can go on the ballot to be affirmed by the voters of the state. If that does not happen, as did happen in the case of no excuse absentee voting, where one chamber, I believe, met that threshold, the House did, but the Senate did not make the 3/4, then the process is that it has to come back for a second go round, but it only has to meet a 50% majority. But that has to be done in a separate legislature. So if it's done in the first year of a 2-year term, it's got to wait till the following legislature is elected and seated before it can be voted on again. So we are here to debate and talk about the second go round of the no excuse absentee voting. So the threshold will be very low for this to pass and become a constitutional amendment up for the public's vote on the election ballot. So seeing that it's got a relatively low bar considered to the first time around, I'm not going to invest a whole lot of time discussing the merit of the policy. The biggest thing I would say about this is that we already have no excuse absentee voting in every way, shape, and form. And I would defy anyone to tell me that we don't, or that somehow someone was precluded from being able to vote by absentee ballot in the last several general elections, because they were. The fact of the matter is that COVID kind of changed the world, and the Secretary of State at the time took it upon herself to effectively make everyone eligible to vote by by absentee ballot by playing fast and loose with the definition of illness. And ultimately, that allowed everyone to participate via a mail-in absentee ballot. And we could certainly discuss whether that was a good or bad policy, given the circumstances of the pandemic. And I think that's why it happened with very little opposition. The problem is that after the pandemic subsided, the process continued. And effectively over the last couple of years, I believe that this General Assembly has gone well beyond the realm of the Constitution. Last year, passing a bill effectively statutizing, if that's a word, the Constitution by redefining the word illness in statute, allegedly to say that that's what the Constitution always said, which makes absolutely no sense to anyone who is using the tiniest bit of reason, because effectively suggesting that anyone would be eligible based on illness without defining that it's their specific illness, or even defining it more broadly to include a relative or someone they care for or some reason that's relevant to that person, just by saying the word illness, you have effectively included everyone, because illness has existed in the past, will exist in the future, and is prevalent in every day of every week of everyone's life in some way, whether it connects to them personally or not. And I bring this up because I just find it completely ironic that we're here to discuss continuing down this road of a constitutional amendment for something we already have, that's been established both by the precedent of the Secretary of State, a challenge made to the Supreme Court of the state of Connecticut, where the Supreme Court effectively said that illness means any illness, anytime, anywhere, since the dawn of humankind, all the way up to the, it's all good. I am often accused of liking to hear the sound of my own voice. So
Sounds great.
I assure you that's not the purpose today, Mr. Chairman, but thank you. So where was I? I was going on and on about no excuse absentee voting and how we already have it. And really, at the end of the day, I mean, that's my issue. You know, we were talking in caucus before this meeting about, you know, the relevance of all the policy that's on today's agenda. And I would just say in more global terms, directly related to the notion of no excuse absentee voting, but talking about voting in general, which is that the majority is clearly laser focused on expanding access to voting. And I'm extremely sympathetic to that. Every one of us on this committee, I think, came to be on this committee because we value our electoral system in this country, and we want to make sure that people are actively participating in our political system. And, there's no greater way for individuals to benefit than to be part of who they're choosing, who their representatives are. So we are all very much in favor of access. And I can tell you that the great frustration that those of us on the minority side have is that every time we try and engage in a discussion about the best way to move forward on access, must contain elements of protecting the integrity and sanctity of the vote. And, sometimes we're pegged as being, against access or trying to suppress the vote and things like that. That's all nonsense. And I think anyone who took the time, even a few minutes, to watch one of our hearings and our discussions would realize that we're here for a very important purpose, which is that, expanding access to elections is great up until the point where people don't trust those elections anymore. And I'm afraid that that's where we are in this country. There is a great many people. I think when I was a kid, I would go back and say, when I was a kid, I don't think anyone that I knew would ever even mention or say or come up with the idea that we have flaws in our election process that are worth discussing. I think people understood that America, being America, had elections that were well run, reliable, and that could be trusted beyond any doubt. That's not true anymore. The last two presidents of the United States and their supporters both have claimed that there were problems in the election. Both losing candidates in both of the most recent presidential elections claimed that there were problems in the elections. People on the street see that there are problems. Now, that's not to say that the allegations made by any of these parties are 100% valid. In fact, I'd say the majority of them are not. I would say that they are greatly exaggerated. But to say that there's no such thing as voter fraud or that there are no problems is also absolutely false. The fact of the matter is that there are problems. And I think those problems stem from pushing our access to voting faster than we can make a process that can be relied on. Connecticut, I think, probably does a better job than a lot of other states in how our elections are run. And I think that's a credit to the people involved. The fact of the matter is that I think we have an excellent workforce on the local municipal level. And I think the fact that we do elections on a town level is also helpful in that regard. And generally speaking, people are dealing with many people that they know personally, and the folks that are running the election are accountable on a personal level. I think that all matters. But we also are missing so many things. Recently, we had a visit from the Secretary of State of Georgia, and just talking with him, we learned so much about what we don't have in Connecticut. Certain things we knew, photo ID. They have photo ID for in-person voting in Georgia. They have photo ID for absentee voting in Georgia. They have photo ID for every type of vote. And from what I could tell, that was also a bipartisan decision there. They also have a verification process that they use on absentee voting, which certainly makes an example of Connecticut and our failure to have any such process. We have no signature verification. We have no effective means of determining whether or not the right person actually completed that ballot application. And that's a concern. We should have a mechanism that makes it very, very hard to go around our system. And more importantly, so that people can regain their trust in our election process. I've said during several of the debates that we've had in this committee on some of the election bills, that they should be bipartisan votes. There's no reason why we shouldn't be able to get together and discuss the rules of the game, which effectively that's what voting is. I mean, that's not a policy that should be debated like, gun control or abortion or something like that, where there's, extreme ideological differences. This is just agreeing to the fact that our baseball games can have 9 innings and 3 outs and that sort of thing. We should be able to have that conversation, and it should be done on a bipartisan basis. And I'm saddened that, almost every time we have a debate on one of these really substantive issues like early voting or no excuse absentee voting, that it always ends up on a party line, and for legitimate reasons. And maybe they are ideologically based, but I don't see that we could be so far off on agreeing to the rules of the game that we couldn't really be an example to the rest of this legislature and to politics in general, that we could actually listen to one another enough to come up with something that everybody agrees with. I'll say a final word about the no excuse absentee voting, because I know that I'm supposed to be talking about these resolutions specifically. And we're certainly going to talk more about early voting when that comes up on our agenda. But my number one issue with this right now, the no excuse absentee voting, is not the no excuse absentee voting at all. It is, in fact, the process by which it's been done. I think, the process that got us to the point where we have no excuse absentee voting without a constitutional amendment today is problematic, and effectively trying to go back and pass a constitutional amendment for no excuse absentee voting after the fact. I don't know what the purpose of that is. And I also wonder what people will say if it ultimately goes to the people of Connecticut, as it has before, and fails, knowing that we are actually living under no excuse absentee voting without this constitutional amendment today. And I'll say one more thing, which is that if I have one complaint about this, it's not that I'm trying to prevent anyone from being able to vote by absentee for no reason, because I am totally fine with that. The problem comes from the fact of where their ballot applications come from. The fact of the matter is that once you establish a system that does not require a specific excuse for a specific voter, now everyone becomes eligible. And now anyone can start providing ballot applications. And we've witnessed this, and I warned against it several times in previous debates on this subject, that what will happen is exactly what has happened. And we saw it in the most recent election, which is that first, we had the issue where the state sent out ballot applications to everyone based on our voter rolls, which is another topic that we could get into, but we'll leave that for now. Or in the following municipal election, I think many municipalities actually sent out the ballot applications. And those two things are bad enough because of the failure of the list to be accurate enough to make sure that everyone was treated equally, and that everyone who was supposed to get one did, and that ballot applications were not sent erroneously to people that should not have them. That's number one. But what happened in 2022 is far, far worse. And that is, the states and the towns did not send them, so various political operators did. Republican candidates for elected office put together a list of people that they thought were inclined to support them, and they sent ballot applications to just those people. Democratic candidates did the same thing. They looked at the list. They said, these people are most likely to support me. I'm going to send ballot applications to them. When that happens, and you start to have politically based operations determining who has more or less access than other people, you have failed at your responsibility of making sure that you have open and fair elections, in my opinion. So because we can't amend this resolution, I'm going to find another place, another way, another time to do it. But it would be my goal that we establish a system where the only person that can request an absentee ballot, even without a reason, assuming no excuse absentee voting becomes the law of the land, is that voter themselves. If you have enough initiative to request the ballot, then you can vote by absentee. But this idea of candidates and political operations, especially ones that are more well-funded than others, having more ability to drive and get out their vote than others, to me is unfair. And I think it's a practice that we shouldn't get into. I'm not going to support this amendment here today, Mr. Chairman, simply because I don't believe it's necessary. I think we are already operating under this system. And if I had some sort of assurance that if we passed no excuse absentee voting as a constitutional amendment and the voters supported it, that we could clean up this process so that we have clean up, we have legitimate voter rolls that everyone could rely on with their accuracy. And number two, we were prohibiting political actors from engaging in the process, including mailing out applications, and leaving it simply to expanding access to voters who will take the initiative on their own to request an absentee ballot. And those are my remarks on that. Thank you, Mr. Chairman.
Thank you. And I realized after I handed over the mic that I had neglected to describe the bill. It is the same exact resolution as was passed previously by this body. And for that reason, it must be identical and cannot take any amendments, as the good senator noted. Are there further comments? Representative Massafrancesco.
Thank you, Mr. Chairman. Mr. Chairman, I won't spend a lot of time on this. I think Senator Sampson pretty much said it very nicely, and I agree with him. We've hashed this out, debates on the floor the last couple of years when we first voted this out. I think we spoke for hours on it. And, my contention on the no excuse absentee is obviously I feel that we already have it, as Senator Sampson said. And I'm not saying that people should fill out an application and lie. I think that's the response I got. So you're saying you're asking someone to lie and say that they were sick. Well, you're not lying, just the mere fact that there's sickness in the world. You can just put that down as an excuse. So the other problem I've always had from the very beginning with the no excuse is two things: that we don't have any policies in place to protect the ballot, to verify the voter. There's no signature verification. And that still stands true today. And that is my biggest problem. If we had all of those safety measures in place, I honestly wouldn't have a problem. I have no problem with people voting by absentee ballot at all. But the other concern I have is that we have a process in place where we can just go out and solicit absentee ballots, which I don't agree with. And I know both parties do it. The Democrats do it during election time and the Republicans do it during election time. They send out applications to voters to get them to vote by absentee ballot. It's certainly a process that I don't agree with. I have received more complaints from my constituents that they've received applications in the mail. They're confused if they're applications or ballots. And it's very frustrating to them, because what happens when they get multiple applications, it puts the doubt in mind of the electorate, the voter, of whether our elections are safe and secure when they get multiple. And anyone can understand that. I get 2 applications in the mail and thinking, what's going on here? So I think putting confidence back in the voter is a big deal for me, because I think once we do that, we'll have more people coming out to vote. And I think if we had protections in place for photo ID, signature verification to verify these, I think voters would feel much more confident, and we would pretty much end this debate that we're constantly having on elections. And again, the solicitation of ballots, I don't agree with that at all. I've always been a firm believer, if you want a ballot, you can simply pick up the phone and call your town and get one. You can go online and request it. There's many ways that you can get a ballot, but you're the person, you are the voter, you are the ones that I believe should have to request it. And I just think it creates more problems when we're out there soliciting the ballots. So, Mr. Chairman, I'm going to be a no on this today, as I have in the past. The same debate, the same conversation I'm sure we'll have on the floor until we can protect our ballots and I guess the chain of custody on those also. I will continue to be a no, but thank you very much.
Thank you, Representative. Are there further remarks on this resolution? Representative Hoxha.
Thank you, Mr. Chair. I just want to, I'm going to be very brief as well, but I I'd be remiss if I didn't speak on this issue, or on this bill and on this issue, at large here, because, I want to just echo what, the Senator Sampson and, Representative Mastro Francesco, what they spoke to, and, just highlight the fact that, I think on top of what they said, we also need to really look at, doing some sort of, purge on the rolls, to remove names, at addresses where those names, those individuals do no longer reside and are no longer, ought to no longer vote, at those addresses because they no longer reside there. And one particular instance that comes to mind is, during my campaign, I came across an address that had 5 different residents registered to live there, but none of those people live there. And this was brought to my attention by the person that did live there, who was not on the list. And, this individual had moved from somewhere else, and they were probably still registered to vote at that previous, address, and hadn't, bothered yet to switch their, voter registration to their current address. And, vice versa for the 5 other residents that were registered to vote there, but that didn't live there. So, I'm not saying that it is, the intention of the current occupier of, that residence to commit voter fraud in the form of requesting absentee ballot applications on behalf of those 5 listed voters at that address. But the tinder for the fire is certainly there. And like Senator Sampson, said, there are, actors out there, operators out there, that would be interested in exploiting a situation like that. So I think, it really would behoove, this committee and this legislative body to address that the ammunition that is all over the place for potential voter fraud. If it could happen in my district, it could happen in any district. I happen to notice it while, conducting my campaign activities. But I'm sure that if, that this was examined with a more fine-tooth comb, that, we would see instances of the situation that I just described everywhere in the state. And it does not immediately constitute, voter fraud. It's just, the carelessness of an individual to not properly change their, voter registration doesn't immediately constitute for fraud or the intent to commit fraud, but it provides the ammunition or, the tinder to do so, to start that fire. So I would just, I'm going to be a no on this as well. And I would just encourage, this committee to examine weeding out that that issue, that that minor issue, but that could turn into a much bigger electoral issue in the future. So and that's all I have. Back to you, Mr. Chair. Thank you.
Thank you, Representative. Is there further comment on this resolution? Seeing none. This motion is a joint F to the floor, or JF to the floor, joint favorable. Seeing no further remarks, Madam Clerk, would you please call the roll?
Senate Joint Resolution 29 JF. Flexer,
Senator Flexer votes yes.
Blumenthal,
Blumenthal votes yes.
Slap. Morinbello,
Rep. Morinbello votes yes.
Sampson,
Sampson is no.
Mastro Francesco,
Masha Francesco is a no.
Burger Giovanni,
Burger Givallo is a yes.
Bronco,
Bronco votes no.
Carpino,
Representative Carpino votes no.
Haddad,
Representative Haddad votes yes.
Hoxa,
Representative Hoxa votes no.
Kana,
Representative Kana votes yes.
Labriola,
Representative Labriola votes no.
Marks,
Senator Marks votes yes.
McCarthy Vehy, McCrory, Parker, Santiago, Rosario, I apologize.
Rosario, yes.
Santiago,
Santiago votes yes.
all set, Mr. Chair. Thank you.
Thank you, Madam Clerk, and all votes for this meeting will be held open at least until the end of the meeting. All right, so next up, we have item number 2, which is House Joint Resolution number 1, a resolution approving a state constitutional amendment to allow no excuse absentee voting. This is exactly what it says. It's identical to the previous item, and I will entertain a motion to JF it to the floor. Moved by Senator Flexer, seconded by Representative Berger Giovanni. I just previously described this resolution. Are there any remarks on this resolution? Seeing no additional remarks on this resolution, Madam Clerk, would you please call the roll?
House Joint Resolution 1, JF to the floor. Flexer,
Senator Flexer votes yes.
Blumenthal,
Blumenthal votes yes.
Slap, Morinbello,
Rep. Morinbello votes yes.
Sampson,
Sampson is no.
Master Francesco,
Master Francesco votes no.
Burger Giovanni,
Burger Givallo votes yes.
Bronco,
Bronco votes no.
Carpino,
Representative Carpino votes no.
Haddad,
Representative Haddad votes yes.
Hoxa,
Representative Hoxa votes no.
Khanna,
Representative Khanna votes yes.
Labriola,
Representative Labriola votes no.
Marks,
Senator Marks votes yes.
McCarthy Vehy, McCrory, Parker, Rosario,
Rosario votes yes.
Santiago,
Santiago votes yes.
all set, Mr. Chair. Thank you.
Thank you, Madam Clerk. Next up, we have item number 6, Senate Joint Resolution number 35, a resolution proposing a state constitutional amendment to allow individuals who have attained the age of 16 to apply for admission as electors and to be so admitted upon attaining the age of 18. I'll entertain a motion to JF this to the floor. Moved by Senator Flexer, seconded by Representative Berger Giovanni. This resolution does exactly what it says it would do. It would allow those who have attained the age of 16 to, on their 16th birthday, file an application that would then, when they turn 18, automatically register them to vote so that they can do so once they have attained the appropriate age. Are there any remarks on this resolution? Representative Master Francesco.
Thank you, Mr. Chairman. A couple quick questions on this particular bill.
Whenever you're ready.
At the age of 16, it says that they need to apply. Do they have to go down to motor vehicle, apply within their town hall? How does one apply? Through you.
Through you. The amendment that we are setting out today would not provide for the exact process by which to do it. We would be able to do that by legislation. But what this resolution would do would allow the voters of Connecticut to determine whether they would like us to create a process by which a 16-year-old can apply to be registered to vote automatically on their 18th birthday. So this resolution doesn't answer those questions, but we would, if it did pass and become part of our Constitution, then address those questions.
Thank you for that. So technically, and this is where I always get concerned with these constitutional amendments because they're not very clear. Kind of like we did with the early voting, we wanted it to be so many specified, so many days and so forth. But It says here, the question I'm assuming that'll be on the ballot, shall the Constitution of the state be amended to allow pre-registration to vote for citizens who are 16 years old, with such citizens becoming fully registered to vote on their 18th birthday? There's nothing in here that says shall the legislature provide. Is that correct, Mr. Chairman?
I believe that is correct. That it does not explicitly say that the legislature shall so provide, but I believe it is implied by the structure of the resolution.
So technically, the legislature can just automatically vote. They would come up with a policy, kind of like we did for early voting. That as soon as somebody turns 16, they're automatically pre-registered. And that's something that the legislature can do based on the language of this. Is that correct, Mr. Chairman?
Yes, if this resolution were to be passed through both houses of the legislature, twice if it's a simple majority, as we addressed previously, or only once if it were a 3/4 supermajority, it would then go to the voters, who would then vote on whether this amendment should be made to the Constitution. If they did so vote, then the legislature would then have the opportunity to consider what the exact program of pre-registration should be.
Thank you for that clarification. So I am correct. The legislature can decide. And here's where I always have an issue, and certainly please don't anybody take this the wrong way, but the Democrat Party obviously in Connecticut are in the majority. And when I always hear a question that the legislature may decide, it sounds good, but it's really the majority party that's in control, whether it's Democrat or Republican, really makes those decisions. And that is true. Even, like with early voting, we've asked, we want to be included in the conversations. And we weren't, but because it's the majority that's really going to sit down and make those decisions. So I think it's just, I just want the public to really understand that. It's not that we don't try to work together, but let's be honest, we are in the majority. We are not going to make the decision. We are in the minority. I wish we were in the majority, Senator. Thank you for correcting me, but we are in the minority, and it is not the minority party that will make these decisions. It's always the majority. And this is the contention I have, because it's very vague. You can turn 16, you can automatically become registered. You can go down to motor vehicle. It could be a policy where you go down to motor vehicle, you get your learner's permit, and you're automatically registered. And the other concern I have with this is that if somebody pre-registered at the age of 16, what happens when they're 18 and they're no longer living in the state of Connecticut? Maybe they move to another state. What does that do to the voter rolls? Do you think an 18-year-old is really going to say, oh, I was pre-registered when I was 16? Do you really think they're going to remember that? I mean, some may. Do you think they're going to contact the state of Connecticut and say, gee, I've moved? These are serious issues and things that we certainly should be concerned about. So I'm certainly not going to support this bill for a constitutional amendment to allow 16-year-olds to pre-register to vote, because I believe there's too many unanswered questions. And unfortunately, when it comes to the legislative part, it's not likely that we'll have not much input in it anyway. And that's it. Thank you, Mr. Chairman.
Thank you, Representative. Are there further remarks on this resolution? Senator Sampson.
Thank you very much, Mr. Chairman. I'll just briefly piggyback on my colleague, Representative Mastro Francesco's comments. I guess I don't know that this would be a bad policy. I mean, it's very similar to the policy that we have currently. Please correct me, anyone, if I'm wrong about this, but I think that you can pre-register right now if you're 17 years old. So, and that is allowed because our Constitution does stipulate that ability to occur. And I guess just on top of the things that Representative Mastro Francesco mentioned, my number one issue with this is that it's a constitutional amendment. I have this belief that the Constitution of our state and our country certainly has a mechanism to be changed, but it shouldn't be changed for light or transient causes, I think is the most apropos language. And I just see this as completely unnecessary based on so many other factors. I mean, the fact is you can do it when you're 17. We also have election day registration in Connecticut. And in fact, the early voting bills that are before us, all of them contain the provision that election day registration will exist throughout the period of early voting, whatever that is. So you're going to have plenty of opportunity and ample options for someone looking to register to vote. Even if they show up to vote on the same day, they can register in Connecticut. I just think this is a bill in search of something it doesn't need to be searched for at this point, based on the other things we have. And again, if it was just a bill change that we could do because it was allowed in our Constitution, I might support it because I don't see any reason not to. I don't want the citizens of Connecticut to feel like they've got to, weigh in on a change to our Constitution at the ballot box every time they go. The Constitution is supposed to be kind of our rock that we lean on because it is the basic structure of our government. And I'm not against changing it. I'm just against changing it willy-nilly every year. And it seems to me we've had a tremendous number of constitutional amendments that have not just been proposed, because there's dozens of proposals every year. I'm probably guilty of some of them. But the fact of the matter is we're just doing too many. And we should leave our constitutional changes for things of real substance unless there is a genuine need. And I just don't see a genuine need in this particular case. So I'll be voting no. Thank you, Mr. Chairman.
Thank you, Senator. Are there further remarks from the committee? And with that, I would just emphasize that I believe that this resolution will increase access to registration to the vote. When individuals in Connecticut turn 16, they often have their first interaction with the Department of Motor Vehicles, and that is a very good place with them to interact with the state and potentially request the opportunity to be registered when they're 18. So I hope my colleagues will support this resolution. With that, Madam Clerk, would you please call the roll?
Senate Joint Resolution 35, JF to the floor. Flexer,
Senator Flexer votes yes.
Blumenthal,
Blumenthal votes yes.
Slap, Morinbello,
Morinbello votes yes.
Sampson,
Sampson is no.
Master Francesco,
Master Francesco votes no.
Burger Giovanni,
Burger Giovanni votes yes.
Bronco,
Bronco votes no.
Carpino,
Representative Carpino votes no.
Haddad,
Representative Haddad votes yes.
Hoxa,
Representative Hoxa votes no.
Khanna,
Representative Khanna votes yes.
Labriola,
Representative Labriola votes no.
Marks,
Senator Marks votes yes.
McCarthy Vehi, McCrory, Parker, Rosario, Santiago,
Santiago votes yes.
all set, Mr. Chair. Thank you.
Thank you, Madam Clerk. Now on to more delicious fare. Item number 7, Senate Bill V390, an act designating pizza as the state food. I will entertain a motion to JF this bill to the floor. Many movements, many seconds. I'll give the movement to the motion to Senator Flexer, the second to Representative Burger Giovanni. This is a bill that would declare Connecticut pizza the best pizza in the world, the state food of Connecticut. Are there any remarks from the committee? Representative Master Francesco.
Mr. Chairman, well, first of all, just the mention of pizza, I'm hungry and I'm sure everybody is in here, and I absolutely love pizza. Who doesn't love pizza? So believe it or not, last year when this bill came on the floor, actually, I supported it. And then after that, I started thinking about it and I'm saying, you know what, here we are, a body of 187 people. are we the ones really to make the decision of what the state food is? There's what, 3.6 million people in the state? I'm thinking, if we ever done a survey to decide what they like, I mean, if it was up to me, I'd have pasta bazool or macaroni or pasta or something to be state food, right? Everybody has their own preference. And I think everybody in here loves pizza. So my only concern is really at 187 people, should we be making that decision for everybody in the state? I don't know. I think I'd feel better if there was a survey or something out there where we kind of got the feel for people, like, what do you really think? As opposed to just making that decision. So I love pizza. We have the best pizza in this state. There's no doubt about it. And I'm only voting no today for that one reason, because I don't really feel that I really want to make that decision for people. Believe it or not. I may change my mind when it comes to the floor, but for today, I'm going to flag it with a no. Thank you, Mr. Chairman.
Thank you, Representative, and let the record show Representative Massafrancesco in favor of direct democracy. Is there any further comment on this bill? Senator Sampson.
Thank you, Mr. Chairman. Well, let me state for the record that Connecticut does have the best pizza in the world, whether this bill passes or not. And I think that is to my colleague's point, which is that I don't think the legislature needs to comment on whether or not Connecticut has the best pizza in the world. I think we know that whether the legislature says so or not. In fact, in many ways, I think that the legislature voting to make it so diminishes that fact. And I'm going to be a no today also. And mainly because of several things that have happened to me over my tenure here at the Capitol. I remember one time being in the House chamber at about 4:30 in the morning after we had debated a number of items. And I think we were waiting on some monumental, important bill. And of course, it wasn't ready yet, or the majority was, trying to get their members in line, or who the heck knows what was happening. But we were voting on random items. And I remember voting on the state medal being titanium at like 4:30 in the morning. And I remember being pretty aggravated by that subject matter. And since then, I've had quite a few constituents come up to me over the years and say to me, I saw in the news, you guys were voting on the state dog or state, bird or whatever. It's like, don't you have better things to do? And I completely, understand and conveyed to them, that obviously we do a lot of things, so we can walk and chew gum at the same time. And even though there are a lot of important issues, we do have time to do some other maybe less important items as well. But the sentiment is there, and I think it shouldn't escape any of us that we're here to do serious business. We're going to discuss a major change in Connecticut law. For the first time since Connecticut began, election day is going to expand potentially beyond election day. That's a pretty consequential and pretty heavy measure that should be taken absolutely seriously. And I think it's maybe the most serious thing we'll do in this legislative body this year. It may be the most serious thing that I have a opportunity to participate in my whole, time in politics. And to have, pizza as the state food on the same agenda is a little ironic in my opinion. So I'll be voting no. Thank you, Mr. Chairman.
Thank you, Senator. Are there further remarks on this bill? Seeing none. Madam Clerk, would you please call the roll?
Senate Bill 390 JF to the floor. Flexer,
Senator Flexer votes yes.
Blumenthal,
Blumenthal votes yes.
Slack, Morinbello,
Morinbello votes yes.
Sampson,
Sampson is no.
Mastrofrancesco,
Mastrofrancesco votes no.
Burger Givallo,
Burger Givallo votes yes.
Bronco,
Bronco votes yes.
Carpino,
Carpino votes yes.
Haddad,
Representative Haddad votes yes.
Hoxa,
Hoxa votes yes.
Kana,
Representative Khanna votes yes.
Labriola,
Representative Labriola votes yes.
Marks,
Senator Marks votes yes.
McCarthy Vehi, McCrory, Parker, Rosario,
Rosario votes yes.
Santiago,
Santiago votes yes.
all set, Mr. Chair. Thank you.
Thank you, Madam Clerk. Next up on our agenda is item number 8, HB number 6868, an act concerning the qualifications of the Attorney General. I will entertain a motion to JF this bill to the floor. Moved by Senator Flexer, seconded by Representative Morin-Bello. This bill will modernize and clarify our 126-year-old statute, setting out the requirements to serve as Attorney General. This statute is ambiguous and the most restrictive in the country, and as a result has caused litigation in a number of the past few elections. This bill, while establishing basic residency and practice requirements, will also ensure that the voters and not judges in litigation get a chance to decide who should be the state's Attorney General. Are there any remarks on this bill? Representative Massey-Francesco.
Thank you, Mr. Chairman. Just a couple of quick questions for clarification on this. I guess I want to know who really benefits by reducing the years from 10 to 6. Can you explain why we're doing that? I know you said that it's a language that's over 100 years old, but who really benefits from it?
I think the voters do. Currently, under our statute, all sorts of attorneys of all sorts are excluded, regardless of their actual level of experience. There are individuals who have been engaged primarily in federal practice. Currently, they do not qualify. There are individuals who may have practiced significantly or primarily in New York State or in another neighboring state before coming to Connecticut. They may not qualify. There may be professors who practice but not necessarily in Connecticut or may not be barred in Connecticut, and they may not be qualified under the current statute. And many others, women who may take a break during having a family or step back and work part-time or maybe wait to get barred in Connecticut. And so allowing all sorts of individuals who have these basic requirements that they've practiced in Connecticut for 6 years, that they're barred here, that they're in good standing, would allow the voters to have the opportunity to determine who has the best qualifications to be Attorney General.
Thank you for that. So my question is, look, at 10 years you're practicing, and when you're out of practice for a couple of years, you get kind of I'm gonna say the word rusty, but you lose a little bit because you're not practicing all the time. The Attorney General's office is a very, very important office to hold. I think keeping it at 10 years, it's worked over all of these years. I don't think we've ever had any issues or any problems. I'm just curious why we were doing this. Is our current Attorney General going somewhere, and is the spot going to be open, or is it just so it allows more opportunity for people to possibly fill that position? But in my opinion, I think 10 years, it's been working fine. I haven't had any problem. We haven't had any problems as far as we know. Would you know, Mr. Chairman, if there's been any issues?
Well, I think the issue that has been created by this statute is the litigation amidst an election. And we've had that on a number of occasions in recent elections related to the Attorney General. And the problem that creates is unpredictability for the voters. And it also allows this statute to be used as essentially a political weapon. And so if you're asking why now, the now is that we are not in the midst of an election. No one stands to gain or lose politically by doing it. And so this is the time to do it, to ensure that that we can allow the voters to consider who the person should be to fulfill this role, rather than allowing unelected judges or forcing unelected judges to do that for us.
Understand. Thank you for that clarification. As I said before, I think the 10-year statute is fine. I think the more you're practicing, the more you are prepared to hold such a prestigious office and really an important one, I think, in not only the state of Connecticut, but really in any state. So I'm gonna vote no today to flag this. But I appreciate you clarifying that for me. Thank you, Mr. Chairman.
Thank you, Representative. Is there further comment on this bill? Seeing none, Madam Clerk, would you please call the roll?
House Bill 6868, JF to the floor. Flexer,
Senator Flexer votes yes.
Blumenthal,
Blumenthal votes yes.
Slat. Bello,
Bello votes yes.
Sampson,
Sampson is no.
Master Francesco,
Master Francesco votes no.
Burger Girbalo, Bronco,
Bronco votes no.
Carpino,
Carpino votes no.
Haddad,
Haddad votes yes.
Hoxa,
Hoxa votes no.
Kana,
Kana votes yes.
Labriola,
Representative Labriola votes no.
Marks,
Senator Marks votes yes.
McCarthy Vegi, McCrory, Parker, Rosario, Santiago,
Santiago votes yes.
all set, Mr. Chair. Thank you.
Thank you, Madam Clerk. Next up is number 9, HB number 6871, an act concerning election recanvass procedures. This is a JF to the floor. I will entertain a motion. Moved by Senator Flexer, seconded by Representative Haddad. This bill would modernize our procedures for a recanvass of an election. In other words, a recount. It would specify the tabulators used. It would specify how the procedure is done and what time, and also who may observe. Are there any remarks on this bill? Senator Sampson.
Thank you, Mr. Chairman. I just want to thank the chairs for bringing this bill forward. I think overall, I think this is excellent policy changes that will certainly help. I have, witnessed, been a part of a few different recount situations, including my own. The first time I was elected, I was involved in a statutory recount myself. And I was certainly watching and observing at a recount that happened in the town of Southington most recently. And I think in particular, the final section of the bill encapsulates something that I think is very, very important, which is that there was a disagreement among some individuals, not in Southington, but I heard this happen in other places, over what the definition of observe really means. Some registrar might believe that allows folks to come up close and personal and watch the ballots going into the machine, and other ones felt that you could observe, but across the room, please, where you can't really tell what's going on. And I think it's very important that we clarified that situation, and it will, assuming this bill does become law, it does read, any party representative present shall have a right to view each ballot as it is being recanvassed by the recanvass officials, so as to be able to discern the markings on such ballot. And I think that's a crucial and important key part of doing an appropriate and proper recount. And I'm glad that we've made that clarification in the law. The rest of the items, I don't know that some of our election officials will be pleased that there is a mandate in here to require them to watch an instructional training video. But my understanding is this is a short 8-minute video that they will watch along with their staff prior to the recount. I don't know that it's too much to ask necessarily. So I'm going to support this today and look forward to seeing how this progresses on the floor. And thank you very much again, Mr. Chairman. That's an important key thing that I wanted to see happen.
Thank you, Senator. Are there further remarks on this bill? Seeing none, Madam Clerk, would you please call the roll?
House Bill 6871, JF to the floor. Flexer,
Senator Flexer votes yes.
Blumenthal,
Blumenthal votes yes.
Slat, Bello,
Bello votes yes.
Sampson,
Sampson is yes.
Master Francesco,
Master Francesco votes yes.
Burger Gervalo, Bronco,
Bronco votes yes.
Carpino, Haddad,
Haddad votes yes.
Hoxa,
Hoxa votes yes.
Kana,
Kana votes yes.
Labriola,
Representative Labriola votes yes.
Marks,
Senator, excuse me, Senator Marks votes yes.
McCarthy Vehy, McCrory, Parker, Rosario, Santiago,
Santiago votes yes.
all set, Mr. Chair, thank you.
Thank you, Madam Clerk. Next up is item number 10, HB 6872, an act concerning faithless presidential electors and authorizing mandamus actions related to the certification or declaration of election results. This is a JF to the floor. I will entertain a motion. Moved by Senator Flexer, seconded by Representative Haddad. This bill would essentially ensure that if a presidential elector in a presidential election or one of the several state officials responsible for certifying an election in all elections refuses to do their duty despite all evidence being that the election was properly executed. It provides for court mandated procedures to ensure that the election is actually certified and goes forward, thus eliminating a loophole in our current laws. Are there any remarks on this bill? Seeing none. Madam Clerk, would you please call the roll?
House Bill 6872, JF to the floor. Flexer,
Senator Flexer votes yes.
Blumenthal,
Blumenthal votes yes.
Slap, Bello,
Bello votes yes.
Sampson,
Sampson votes no.
Master Francesco,
Master Francesco votes no.
Burger Gervalo, Bronco,
Bronco votes no.
Carpino, Haddad,
Haddad votes yes.
Hoxa,
Hoxa votes no.
Kana,
Kana votes yes.
Labriola,
Representative Labriola votes no.
Marks,
Senator Marks votes yes.
McCarthy Vehy, McCrory, Parker, Rosario, Santiago,
Santiago votes yes.
all set, Mr. Chair, thank you.
Thank you, Madam Clerk. Next up is number 11. House Joint Resolution number 10, a resolution commemorating the 24th anniversary of Connecticut-Taiwan sister state relationship. This is a JF to the floor. I will entertain a motion. Moved by Senator Flexer, seconded by Representative Haddad. Is there any comment on this resolution? Seeing none. It is exactly what it sounds like, and I would ask Madam Clerk to please call the roll.
House Joint Resolution 10, JF to the floor. Flexer,
Senator Flexer votes yes.
Blumenthal,
Blumenthal votes yes.
Slap, Bello,
Bello votes yes.
Sampson,
Sampson votes yes.
Master Francesco,
Master Francesco votes yes.
Burger Gervalo, Bronco,
Bronco votes yes.
Carpino. Haddad,
Haddad votes yes.
Hoxa,
Hoxa votes yes.
Kana,
Kana votes yes.
Labriola,
Representative Labriola votes yes.
Marks, McCarthy Vehi,
Oh, I missed it.
Marks,
Senator Marks votes yes.
McCrory, Parker, Rosario, Santiago.
Santiago votes yes.
All set, Mr. Chair. Thank you.
Thank you, Madam Clerk. Next up is item number 12, House Bill 6826, an act concerning liability for false and fraudulent claims. This is a JF to the floor. I will entertain a motion. Moved by Senator Fluxer, seconded by Representative Morin-Bello. This bill deals with our current State False Claims Act. Currently, that law limits the Attorney General to investigating and pursuing false claims related only to healthcare services. This leaves a large proportion of our state's taxpayers' dollars and state contracts exposed without the accountability of this False Claims Act and its powers. The bill before us would expand the power of the Attorney General to investigate and pursue those claims to all contracts rather than just those in the healthcare field. Is there any comment on this bill? Representative Master Francesco.
Thank you. Thank you, Mr. Chairman. Just a question for clarification. Right now, if there's a claim filed, a contractor, they're billing something and it's a false claim, who is overseeing that process right now?
So there are a variety of contracting regulations and overview processes, and who actually reviews them depends on the particular contract, its size, and other elements. It may be the Department of Administrative Services. It may be an independent agency, depending on the contract. But what we don't have right now is a method by which if payment is demanded in a situation where the contractor is not telling the truth, where that can be divined, where it can be pursued, and where compensation can ultimately be sought from this fraudulent contractor, or fraud, I shouldn't just say contractor, say anyone who is pursuing payment from the state fraudulently. And so this will allow the Attorney General to pursue those claims, to investigate them, and ultimately recover money on behalf of the state, including treble damages, which is a good deterrence for fraud. Through you.
Thank you. So in order for the Attorney General to do, there would have to be, I'm assuming, like a whistleblower that would have to come forward and say that this contract or contractor or whatever is putting false claims in. Would that be correct?
That is the most likely method through which an investigation would be started. I don't think it's the only one, but it's probably the most likely, certainly.
I was like, and I guess right now, I wasn't clear on your answer. Like, who's overseeing that right now? Like DAS, are they overseeing? Do we have any whistleblowers that have come forward? Because the Attorney General just can't take action, right? We need to pass this for the Attorney General to automatically take action. Let's just say somebody comes forward right now to accuse or report that a contractor maybe they work for or so forth is putting in false claims. How do we find that out now? And who's overseeing that process?
So the Auditor of Public Accounts has, as an office, some responsibilities and can refer some matters to the Attorney General's office. There are certain areas, especially within the healthcare field, within which the Attorney General has their own authority to pursue them. But for a lot of these claims, they are brought to the public's attention. There may be criminal charges that are in order, but the Attorney General of the state has no opportunity to investigate them themselves, especially in situations where there may not be necessarily actions rising to the level of criminality. And the Attorney General also doesn't have the opportunity to get this money back for the state. And over the past 15 or so years since our State False Claims Act went into effect in the healthcare field, only about $181 million have been recovered on behalf of taxpayers.
Thank you. And I remember the Attorney General testifying before this committee. I appreciated his testimony. I certainly understand the concern. We don't want anybody filing false claims of contracts within the state of Connecticut, and certainly something we need to monitor. I do have some concerns on it, though. I do need to do a little bit more research. So I understand the intent of this bill. I'm going to flag it with a no today, get a little bit more information, and we'll see what happens when it comes to the floor. Thank you, Mr. Chairman.
Thank you, Representative. Is there further comment on this bill? Senator Sampson.
Thank you very much, Mr. Chairman. Yeah, so I'm very close to supporting the legislation that's before us. I know that there were some concerns about this bill when it came before the General Assembly in a previous year. It may have been last year. I know it went to the Judiciary Committee. And I know that over there, the concern was really the breadth and width of the Attorney General's authority. And the one thing that I think raised the most concern is that the potential was there for him to start to investigate information relative to the payment of taxes to the state. And I noticed that that section was removed, or it's not removed, but there's a statement made in lines 102 to 104 saying that the provisions of this section shall not apply to any claim, record, or statement made or presented relative to the payment of taxes to the state. So I think that's a good thing. And I think it gets it a whole lot closer to being in a place where I could support it. I remember the conversation I had with the Attorney General here during our public hearing, and he made a very compelling argument about how this authority should expand beyond the realm that is in the current statute, which is the healthcare field itself. And I don't disagree. And in fact, I'm someone who is kind of a hawk as far as the taxpayers' money, and I want to make sure that the state is not paying out more than it should. And if there are bad actors out there that are engaged in defrauding the state for money, they ought to be prosecuted. And I don't know that we have a prudent method currently. It's something that I need to learn more about too, to find out exactly what happens in the case of a contractor dealing with the state. And there is some issue of a claim made that, work was completed that wasn't actually completed or something like that. What exactly happens? How's that process go forward? I guess the only reservation that I have about this bill still is in the underlying law, which effectively says that the penalties are substantial. And I don't know that it's someone didn't purposely draft the original law to say that if you're in a state administered health or human services program, that you should face really severe penalties. It looks like treble damages and some other types of things are included in the penalty provisions at the end of the bill, subsection B, it looks like, of section 2. So I don't know. I mean, to me, that's the number one thing. It's like, I do want to make sure that we have the ability to investigate and prosecute wrongdoers. Although I don't know, without being a little more certain that this is the appropriate method to get there. Giving the authority to the Attorney General is one thing, but giving the authority to the Attorney General to levy such very, very significant fines and penalties does concern me a little bit. So hopefully we can have a conversation about this going forward. I will vote for it today in the interest of making it clear that I don't disagree with the notion of the policy idea, but I think it needs to be done fairly. I know that the vast majority of the testimony that we saw was coming from people that are doing contract work with the state, and I get that. And I'm certainly sympathetic to them, and I want them to know that as well, that I'm not in favor of seeing them punished for things that they didn't knowingly or willingly engage in that are unlawful. But anyway, those are my comments today. Thank you.
Thank you, Senator. Is there further comment on this bill? Further comment? Seeing none, Madam Clerk, would you please call the roll?
House Bill 6826 JF to the floor. Flexer.
Senator Flexer votes yes.
Blumenthal,
Blumenthal votes yes.
Slap,
Senator Slap votes yes.
Morinbello,
Bello votes yes.
Sampson,
Senator Sampson votes yes.
Master Francesco,
Master Francesco is gonna flag this one with a no for today. Thank you.
Burger Givallo,
Votes yes.
Bronco,
Bronco votes yes.
Carpino, Haddad,
Haddad votes yes.
Hoxa,
Hoxa votes yes.
Kana,
Kana votes yes.
Labriola,
Representative Labriola votes no.
Marks,
Senator Marks votes yes.
McCarthy Vehi, McCrory, Parker, Rosario, Santiago,
Santiago votes yes.
all set, Mr. Chair, thank you.
Thank you, Madam Clerk. Number 13 is our next item. HB 5720, an act reestablishing the Legislative Program Review and Investigations Committee. It is a JF to the floor. I will entertain a motion. Moved by Senator Flexer, seconded by Representative Burger Givallo. This bill would reestablish a former standing committee of the legislature that was empowered to investigate programs and issues, especially related to the executive branch of the state, and conduct oversight. It was a bipartisan committee with an equal number of Republicans and Democrats from each house of the legislature. And this bill would reestablish it in its former form. Is there any other remark from the committee? Seeing none, seeing none, Madam Clerk, would you please call the roll?
House Bill 5720, JF to the floor. Flexer,
Senator Flexer votes yes.
Blumenthal,
Blumenthal votes yes.
Slap,
Senator Slap votes yes.
Morinbello,
Rep. Bello votes yes.
Sampson,
Sampson votes yes.
Master Francesco,
Master Francesco votes yes.
Burger Givallo,
Votes yes.
Bronco,
Bronco votes yes.
Carpino,
Representative Carpino votes yes.
Haddad,
Haddad votes yes.
Hoxa,
Hoxa votes yes.
Kana,
Kana votes yes.
Labriola,
Representative Labriola votes yes.
Marks,
Senator Marks votes yes.
McCarthy Vehi, McCrory, Parker, Rosario, Santiago,
Santiago votes yes.
all set, Mr. Chair, thank you.
Thank you, Madam Clerk. Next up, we have item number 3 on our agenda. Senate Bill number 1057, an act concerning the Secretary of the State and early voting. This will be a JFS to the floor of LCO number 6112. I will entertain a motion. Moved by Senator Flexer, seconded by Representative Morinbello. This bill would establish a program of early voting in the state of Connecticut. This past fall, the voters overwhelmingly approved a constitutional amendment to empower the legislature to provide for early voting throughout the state. And we will consider today 3 bills that will do that. This one would establish a period of 10 days of early voting, ceasing on the last Sunday before the election, giving local officials that Monday off. The hours would be from 10 a.m. to 6 p.m., except for 2 days on which there would be early and late hours. Additionally, in general, the procedures for transporting, keeping, and storing those ballots would be almost identical to those used for absentee ballots currently. And additionally, the early voting period for special elections would be 4 days. This bill contains no provision for early voting for referenda. And I will just note that the additional 2 items that we will consider today differ in only 2 respects from this underlying bill. The first respect is that the 2 other bills we'll be considering have a period of 14 days of early voting for primaries and special elections. And they also include a 4-day period of early voting for both special elections and referenda, while this first bill we are considering does not include referenda. With that, are there any questions or comments from the committee? And I would just request that if there is a question with reference to a part of the bill, that a line number be included, because these bills are rather long. Senator Sampson.
Thank you very much, Mr. Chairman. And I appreciate you referencing the other bills on the agenda simultaneously. My intent today is to confine my comments really to the bill that's before us. But I hope you'll just grant me the latitude to refer to the other bills occasionally, since, as you mentioned, they are very, very similar except for the timeframes and the inclusion of referendum votes included in the other 2 bills. It'll just simplify our conversation, I think, if we can kind of talk about all 3 of them at the same time, but really focus on 1057 when it comes to the language in the bill and the line numbers, as you had mentioned. As was mentioned early on in the meeting today, we got the final language of these bills just this morning, so we had a limited amount of time to really delve in. And I've been kind of going back and forth in my head about how I want to approach this conversation today, to talk more about the policy and the implementation versus the language of the bill. I'll just go back to some of my earlier comments about the no excuse absentee voting to suggest that, you know, everyone here on the committee is concerned with making sure that the system of voting in Connecticut is as open and unrestricted as it can possibly be, so that we can accommodate our fellow citizens in their ability to be able to participate in representative government, which is something that is extremely near and dear to me. And in fact, I love this country so much based on the concept of the way we govern ourselves, the value of which I'm afraid every day is being lost, because people, I don't know that they consider it as precious as they should, the fact that we live in a truly free country where the people themselves determine what the laws are via the representatives that they elect to serve them. And it is so critically important that that process, the process of elections, is completely confidence worthy, I guess is the word I'm searching for, and that the people trust the outcome, and that it's beyond reproach. And that's been my function in this committee since the first day that I sat here as a member of the GAE committee, which is to say, I'm all for creating laws that are going to expand the ability for people to vote, but we've got to make sure that we keep that trust at the highest level attainable. And so that's what I'm here for today as well. And my comments about this bill are simply in an effort to make this process better and to make sure that if we're going to have this, we're going to do it in a way that I think honors our system and our recognition that our constituents are our bosses. So I want to just go back to the start of the early voting process. I think most of the public has a pretty basic understanding of what has transpired, which is that in order to change our law in Connecticut, we needed to change the Constitution, and that's been achieved. And the process I outlined earlier, talking about the no excuse absentee voting constitutional amendment, is the same. And the early voting constitutional amendment had to pass this legislature one time because it had passed the previous legislature one time as well. And it met that requirement for it to go on to a ballot, and ultimately was put before the people to make a decision. One of the things that I've had a problem with ever since the start of our debate and discussion on early voting is the failure of the constitutional amendment and the question that was ultimately put to the voters to specify any detail whatsoever, including the time frame of early voting. And I think that that remains the number one sticking point on this legislation. Many people, not just me, because I would fall into this category, but I think many people remember voting the first time when they were 18 or thereabouts in life, and recognize our election process as a snapshot in time, and something that we gather once every year or every 2 years in the case of different types of elections to cast our vote for our representatives. And the advent of early voting and broad expansions of absentee voting, I think have kind of changed our vision about what voting is in some ways. But I'll just remind people that, you know, there is a downside to having a long period of early voting. And that is that an election really is a point in time. Things can change. You may have a different opinion about a particular candidate or candidates on one day than you might have on another day, based on things you find out about that candidate, things you find out about their opponent or opponents, things you find out about yourself, and also things going on in the world. You know, you might be choosing one particular candidate because of a position on some issue that might be near and dear to you. And who knows, something might happen to change what is important to you radically. I don't know if I can come up with an example, but, you know, maybe there's one candidate you would feel much more confident from a standpoint of our national security, and God forbid a threat from, you know, China or Russia or something like that was to occur, you would feel much more confident about one candidate over the other. But you might also think that you prefer the other candidate for other issues. Maybe it's taxes or social issues or something like that. Well, suppose you vote for the candidate who's good on the social issues on the first day of early voting, and then ultimately we go to war days later. I think that giving too long a period can really upset the balance of making good decisions on who we're casting our votes for. Not to mention the fact that, you know, our process of elections happens on a timeline. Every person sitting at this dais has been a candidate for office, and they have put together a campaign to run for office and a schedule to do so. You know, starting with, you know, announcing their candidacy and raising money, and then figuring out they're going to spend that money and what methods they're going to use to reach voters and put out information about their positions. And obviously those things are all related directly to election day, because you need to get all of your resources to culminate on that day. And that, I'm talking about this from a candidate standpoint, but this also matters to the constituents that are going to cast their votes, because clearly the candidates have to make their best effort to get this information in front of voters before they cast their vote. But when you start to extend the period of voting, you may be upsetting the ability of those constituents to get all of the necessary information, or preventing candidates from being able to get what's important that they feel that they need to put in front of the voters out in time. And everything else that's connected with that, it has the same concerns and issues. The press being able to communicate issues to potential voters, et cetera, et cetera. So just something to think about. There's a lot of data out there also about states that have explored early voting. And I think the number one focus that people that advocate for early voting often is we want early voting because we want to make sure that we're creating convenience for people. And I'm certainly sympathetic to that. I mean, we want to make sure that it's convenient for people to vote. And obviously, it can be difficult in certain circumstances, based on someone's work schedule or traveling or who knows. And we should try and come up with policies that accommodate that to the degree that is feasible while maintaining the integrity of an election. That's where I would come from on that from a basic position. And that's where we should work to. But states that have gone with very long periods of early voting, many of them have actually shortened the time frame. And they've also recognized that there was not a significant increase in turnout. In fact, in some states where early voting has been rolled out, the actual turnout figure has dropped. So I don't know if we're achieving our goal by doing a broad expansion. As was mentioned, the bill that's before us comes to us from the Secretary of State, her recommendation being 10 days total of early voting, inside, I think, 11 days. And the other bills are for 14 days of early voting. And, we had one of those at the hearing, I think was even as much as 18 days. My position, since we started this debate was, look, I'm in the minority. I don't have a lot to say. If you guys want early voting, we're going to have early voting. Can I please be part of the conversation? Can we please try and do something that's reasonable, especially considering that it's now a constitutional amendment, and it is within the power and the hands of the majority party in the legislature to change this policy as they see fit. So there's no requirement that we go all at once, as fast as we can in a big rush. I would advocate for starting small and saying, look, we don't need 14 days of early voting to start with. We don't need 10 days of early voting to start with. The amendment that has been offered by myself and some of my Republican colleagues year after year when discussing the constitutional amendment was to limit it to 3 days within 5 days. So that would give you the opportunity to capture maybe a Friday, Monday, Tuesday, or a Saturday, Monday, Tuesday, something like that. And I feel like that might be a way to start rather than to go whole hog into a long period, because you have to remember there's a lot more to this than simply suggesting that we need to give more time for people to vote. That has to happen on the ground. The towns run our election process, and they're going to be the ones faced with figuring out the logistics of making this happen. The state certainly is going to have some additional costs, which will be borne by taxpayers. But the towns really are where the action's going to happen. And, they've got to not only staff a polling location or more than one for this time frame. They will need additional poll workers. They will need people who are involved in the counting of ballots. And the entire process has to be worked out on their level on exactly how it's going to work and be coordinated over whatever period of time ultimately we choose for early voting. And I can't stress enough that I think we're asking a lot of these town officials, even to expand it by 1 day, and to do it by multiple days and as much as 2 weeks, I think is really a lot to put on them in a short period of time. I know just talking to people in town government in my district that they have trouble filling all of the slots for poll workers on one election day. I don't know how we're going to manage if it ends up being for a considerable period longer than that. I will say that early voting is attractive to me, especially in Connecticut in the current environment, as a alternative, although it will be used in conjunction with no excuse absentee voting, which, as I mentioned earlier, I believe we already have, irregardless of whether or not the constitutional amendment passes. And the reason for that is that I think early voting simply requires someone to visit a polling location in person and present themselves. It's widely understood. And in fact, anytime we've had debates on this subject matter, people know that I like to quote Senator Martin Looney, because he mentioned during one of our debates several years ago that no one ever can be sure who actually filled out an absentee ballot. That was his comment, not mine. I'm certainly not saying I'm quoting him 100% directly. I don't have it in front of me, but that's the gist of what he said. And it's because everybody knows that. Everybody knows that if there is the potential for problems in elections, it's going to happen in the mail-in type voting versus the in-person type voting. So for me, anything that shifts the focus to more in-person voting to me is beneficial from a ballot integrity perspective. So from that standpoint, I'm in agreement. But I noticed that none of these bills put any emphasis on modifying the current practice for absentee voting. Anyway, I'm going to kind of just go through the bill little by little, just to give the folks listening an idea of exactly how this process is going to work. And I may have some questions along the way. Section 1 of proposed bill 1057 is what lays out the time frame and period of voting. And it looks like it says it consists of 10 days total. And it says such period of voting shall commence on the 11th day prior and conclude on the 2nd day prior to such regular election or primary. Mr. Chairman, I just want to make sure I understand this properly, that sounds like it is going to include the 10 days prior to the election, including Sunday, but will skip Monday. Is that correct?
Through you, Senator Sampson, that is accurate. And the aim behind that provision is to allow the registrars and other elections officials to prepare for election day on the Monday before election day. Through you.
I'm glad that you said that mouthful and I didn't have to. To prepare for election day on election day, they had to have election day the day before worked out. I got it. So no, it makes sense from a logistical point of view, and I completely understand that. I guess the only thing I would say about that provision is that I think it might be somewhat confusing to voters to have them understand that they are going to be able to vote for a significant period leading up to election day, but have to not include Monday as far as early voting goes might be somewhat confusing. And I'm going to kind of get into this conversation at some point in going over the bill about the differences between absentee voting in person and early voting in person, which I don't know that there are many, except that I'll just confirm for the moment that you would still be able to cast an absentee ballot on that Monday. Is that correct, Mr. Chairman?
Through you, yes.
Thank you very much, sir. Yep. Okay, so, and okay. Sorry. So section 2 of or subsection 2 of section 1 is new in the substitute language. And this is the part that has to do with special elections. And it appears that special elections would be included as well, except they would be limited to a total of 4 days, but the same exact process if I'm correct, and please stop me if I'm making a mistake and misreading any of this, but it looks like it will be 4 days, including Sunday, skip Monday, and you will, of course, be able to vote on traditional election day on Tuesday. I will note that this bill differs from the other two early voting bills in that those other voting bills do include language to include primary elections and referendum. And I'll touch more about it once we get to other parts of this language. But as was pointed out, that's the major distinction between the bills, is the time frame and whether or not budget referendum would be included. Moving down line 19, it says the registrars of each municipality shall designate a location for the conduct of early voting. I noticed a change from the language that we had for the public hearing, basically saying that it would reflect only populations of over 45,000 was the language, and now it's going to change to places with at least 20,000. The municipality may choose to have more than one voting location. Mr. Chairman, maybe you could tell me why the change. Is there something in specific in mind why because I think we're going to capture a lot more towns. I don't know how many towns are over 45,000 versus over 20,000, but I think it's a substantial difference. I'm just curious if there's a policy reason behind that.
Thank you, Senator. Yes, there is a reason behind that, and it is that we wanted to expand the availability and the flexibility of the system throughout different towns, which have vastly different circumstances, whether it's geographic area that they cover or populations that they cover. But we did not want to make it an unqualified mandate. So the current procedure in this bill would, for municipalities of 20,000, require them to have a public hearing on the subject of having additional early voting locations. And if they ultimately decide not to have additional early voting locations, which they are perfectly allowed to do, they must state why they made that decision. In the converse, if they wish to have an extra early voting location, that location must be applied to the Secretary of the State and approved by the Secretary of the State.
Thank you very much for that information, Mr. Chairman. I was just going to kind of go over that same process, and thank you for sharing that information. So I guess I only have one question about this process, and that is that we are putting this in the hands of the registrars, and each town typically has one from each major party. So you got one Republican registrar and one Democrat registrar, and we're relying on them to determine whether or not there should be an additional location, ultimately to be authorized by the Secretary of State. But I guess my question is, what happens if they don't agree? There's no tiebreaker vote in a particular situation like that. Has that been contemplated?
Yes. Well, what would happen would be that the Secretary of the State would evaluate the situation, and that's an important part of this inquiry. The Secretary of the State would have the opportunity to determine whether such an extra location or additional location were necessary and proper. And I would imagine that if the registrars did not agree that they were capable of having an additional location, or that one was advised, that the Secretary of the State would do a more searching inquiry and be disposed not to grant that additional location.
All right. Thank you, Mr. Chairman. I appreciate that answer, although I don't know that the language of the bill lays that out as clearly as I would like to see it. Maybe it's something we can incorporate in an updated version. Just moving on, subsection 3 says the registrars of voters may delegate to each election or primary official appointed pursuant to subdivision 1. And I went back and I don't find that subdivision 1, so we may have a drafting error that needs to be addressed. I don't know that it's important other than from a technical standpoint, because obviously those officials are appointed. But just reading on, it says they can delegate any of the responsibilities assigned to the registrar of voters. And I'm just curious if that's something we're grabbing from existing law. I understand that obviously registrars are going to be spread pretty thin through this process. But is that something that we do already? Do we allow them to delegate their responsibilities to their assignees? Through you, Mr. Chairman.
Through you, there is currently provision for deputy registrars, and we have also allowed, under certain circumstances, town clerks to delegate certain of their duties. And as you indicated, this is a provision meant to allow the registrars to delegate some of their authority and duties to better enable them to cover these early vote locations and also to increase their flexibility. We know that towns across the state have different levels of resources, have different provisions for their registrars, and we wanted to give them that extra flexibility.
Thank you for that answer, Mr. Chairman. I'm going to have to take a look at the actual responsibilities of the registrar of voters, which are substantial. Just for my own edification, because I think this is a conversation that may reemerge when we debate this bill on the floor of the House or Senate. Just what that means, what we mean by any of the responsibilities that the registrars themselves has. The next few sections look to speak to the process. As was noted, line 82 says the person shall appear in person, which again, I stress as the one benefit. And the reason why I'm in support of any type of early voting at all is that I think it is advantageous to mail-in voting, which we've been witnessing. Subsection D says that the registrar shall check the statewide centralized voter registration system before allowing electors to vote. I think that's a good provision. The next section, though, it starts talking about if the registrars determine that the elector has not already voted, or if there is no report that the elector has already voted, the registrar shall allow the person to vote. That's obvious. But then the next part says the registrar determines that the elector has already voted, such elector shall not be allowed to vote, and such matter shall be reviewed by the registrar. After completion of such a review, if a resolution, and that's the key word here, if a resolution of the matter cannot be made, such matter shall be reported to the State Elections Enforcement Commission, which shall conduct an investigation of the matter. I presume this means that if there is some wrongdoing, this will be referred to the SEC for that purpose. But I don't think it says that, Mr. Chairman. It just says if there is no resolution. I mean, we've already determined in lines 97 and 98 that they've determined someone has already voted. It seems to me in a case like that, that automatically should be referred to the State Election Enforcement Commission or some other body, not just after completion of such review if a resolution cannot be made. I'm just wondering if there's anything you might add to my concern on this small subsection 2.
Through you, in answer to your question, the intent of this provision is to ensure that all matters that cannot be quickly resolved or explained be referred to the State Election Enforcement Commission for investigation. Obviously, registrars are not the primary investigative function or agency with regard to our elections. There may be cases where there is some sort of confusion or miscommunication that is quickly resolved based on the facts on the ground, and there's no reason to think that there was wrongdoing. But if that determination cannot be made, we want SEEK to have the opportunity to review and investigate anything about the circumstances that may lead to any allegation of wrongdoing to ensure trust in the system. Through you.
Thank you very much, Mr. Chairman, and I appreciate the answer. And I'm in complete agreement with what you said. I don't think that matches the words in the bill. And I would just recommend that, you know, as we go forward, that this section is more clear, because I read this to mean that this is applying to only in the case where it is clear that the elector has already voted. They shall not be allowed to vote. And then it shall be reviewed by the registrar. And if there's not a resolution, I don't know what the resolution could be other than to follow through with some sort of penalty or prosecution for someone that is double voting. Certainly, if there is a prosecution or an investigation done by the Secretary of State or State Elections Enforcement Commission, and for whatever reason it is determined not to be a crime, that's a different thing. It seems awful vague to me that it looks like if they can determine that this person double voted, they can certainly prevent someone from voting a second time, but it doesn't say they'll do anything about it. And I think that if we're serious about preventing voter fraud or election abuse of any kind, I think this should be very clear that not only are you going to not be allowed to vote, you're going to be in some type of trouble for attempting to. Just moving on. I guess starting in subsection F, this is where we get into the language that has to do with the process, which I think, based on the testimony of the Secretary of State, is really going to be a temporary process. I think that the hope is down the road, the state of Connecticut is going to purchase new tabulator machines that will have the ability to, calculate votes without, running a tape or disclosing the tally until a point in the future, something like that. I think that this is the problem that was pointed out to me, which is that we're not going to use the tabulators for early voting, because once you shut down the machine, it does a tally. And it's very important to make sure that that tally is unknown and therefore secret until the election is completed. So I think what's happening is that this process is being developed in this bill language as a means to work around the lack of appropriate tabulator machines. And that's fine. But I will just point out a couple of things. First off, it says pretty much the same exact process is going to occur as occurs with absentee voting. And one of the things that was mentioned to me by people who worked during the previous elections, where we had a great many absentee votes, is that the absentee ballots ultimately are folded. And then once they're folded, they are very difficult to unfold and feed through a machine. I'm just wondering if there's any distinction here about what type of envelopes are going to be used, and what are the differences between the absentee ballot envelopes and process. And I'll just give you a little more background, which is that my expectation is that in most towns, they're going to choose their town hall as their early voting polling location. So people will be walking into town hall the same that they would be if they were going to vote by absentee, to obtain an application or potentially vote right there in person as absentee, because we can certainly do that. And this process looks virtually identical. Mr. Chairman, am I missing anything in making that assumption and assertion that this is kind of more or less the same process, except obviously without the requirement to complete an application first?
I think you're largely correct through you, that the process is very similar. The only exception to that I would note is that, unlike an absentee ballot, there would be no second outer envelope. There would be only the inner, I guess the equivalent of the inner envelope with the affirmation for an early vote. So it would be one fewer envelopes, but there is no provision for that envelope being of a different sort than the traditional absentee ballot inner envelope for you.
Thank you very much, Mr. Chairman. Yeah, so I would just point out that it might be worthwhile speaking with the registrars and clerks to have this conversation about the types of ballots and whether or not they will be folded or not. I don't know what the change will be in turnout over the period of early voting, but if it's substantial, it would be certainly helpful to those folks on the ground to be able to feed these ballots through the machine. But if they're folded, I know from listening to their experience that does present a problem. So just something to put on our radar. The lines 127, 128, 129. This is the part where it talks about how at the conclusion of each day, the registrars are going to transport the receptacle containing the early voting ballots to the clerk. And the clerk is going to, it says if necessary, which is my first question. What does that mean? Store in the fire resistant vault or safe provided for in section 7-27 of the general statutes, which my understanding is probably the vault that the town clerk uses for land records, et cetera. So please confirm that for me. Maybe let me know what if necessary means. And then I have a couple of questions about how this relates to ballot integrity.
Thank you. Through you. My understanding of the if necessary is that it refers to the necessity of the vault or safe as provided in section 7-27 of the general statute. So if a fire resistant vault or safe is required under that provision, then it shall be used and is required. And if not, then it is not. That is my understanding. Through you.
Thank you, Mr. Chairman. So what that means effectively is that there could be storage of the early voting ballots in a place that does not meet the requirement for vault or safe provided for in section 727. That's interesting. I don't know how important it is. I think that's something that we would require some feedback from some local officials to tell us what they would do or what they do in circumstances where they don't have such vault or safe. So that is a question for me. My other questions have to do with who has access to this vault anyway. We're talking about a relatively extensive time frame. Certainly even in this bill with the 10 days, but even more so if it's 14 days, you're asking the registrars to be on top of this voting process every day for an extended period of time. And then we're going to transfer the responsibility of the watching these early voting ballots to the municipal clerk. I guess what concerns me is how this impacts all of these municipal employees and the hours that they work and when they're supposed to be there and when they're not supposed to be there. And I don't know that that's all been worked out at this point. And I don't know if that's another element of what will ultimately become a cost to towns, and whether such changes are even truly viable. But leave that aside. Certainly an issue that we should address better, but leave that aside. Who else has access to the land records vault? Seems to me, I'm a realtor. I mean, I've been in the land record vault, God knows how many times. Does that mean that that people that are viewing land records and so forth are going to have access to the same room where we are storing our ballots for the purpose of their security?
Through you, Senator, thank you for the question. So with regard to the personnel issues, the procedure should be almost identical and as a result, pretty smoothly added to the current responsibilities of the town clerk with regard to absentee ballots. And while they would have to be segregated from absentee ballots, the early voting ballots would be stored in the same rough location. They have to be stored under section F or subsection F, excuse me, in a secured early voting ballot depository receptacle. So the town clerk would have to maintain the security of that area, obviously, and govern access to the area. But the ballots would also be provided, or it is provided that they would be stored in this secure ballot depository receptacle, which would keep them segregated, not only from the people coming into the room, but also from the absentee ballots. Through you.
Thank you very much, Mr. Chairman. Yeah, no, and I appreciate the answer and it's, you know, pretty much what I expected. I just don't know if that's adequate or secure enough to satisfy, you know, concerns over whether or not the ballots are going to be monitored, whether there's a clear person in charge of their custody at all times. I don't know what happens when the clerk, you know, is out to lunch and someone comes in needing to look at the land records. My experience is that the door to the land record vault is usually open during business hours and people kind of come and go. I think it depends a lot on the town. So just another thing that I think warrants some feedback, and much of the reason why I'm going through the bill in such detail for the benefit of the people listening really is because I'm hopeful that there are people that serve in town government in the capacity as registrar or town clerk, et cetera, who need to know this information and might react to it in some way where they provide us with some advice and, you know, better way of achieving our end goals. The focus obviously being on making sure that we maintain a clear, you know, record of custody and that the ballots are secure. The end of that section F is about the counting of the number of ballots, if I'm correct. I was reading through this and I thought that the language was a little hard to follow, but just to confirm, this is only about the recording of the total number of ballots cast during the early voting process on a day-to-day basis. Is that correct, Mr. Chairman? And is it proper that that would be filled out on the head moderator's return in advance of election day? I know that now that form's just filled out on election day, and I guess that they're going to be hanging on to this form during the entire process and filling it out as time goes on. Is that the way it's envisioned through, Mr. Chairman?
Yes, that is my understanding under this language.
Thank you, sir. The next section, section G, references Title IX, which is the authority that the Secretary of State has. Again, it says as nearly as possible. It says regulations adopted under Title IX concerning the procedures related to the custody, control, and counting of absentee ballots shall apply as nearly as possible to the custody, control, and counting of early voting ballots under this section. I guess we're giving some direction to the Secretary of State there that says you should do this like we are telling you in this bill. I think that's somewhat interesting. Section 8 is the 75-foot rule, which is something, you know, we had a little conversation in our caucus about that. You know, assuming this is not a typical polling location, you know, a school or firehouse or something like that, and it's actually going to be in the town hall, I can just see, you know, some issues with this. Certainly, I mean, the point of the 75-foot rule is to keep, you know, candidates and people promoting different candidates, you know, at a distance from the actual voting. I don't know how viable that is in a town hall where you've got people coming and going and interacting with one another. And, you know, I made a joke in our caucus about somebody complaining about their tax bill at the tax desk. I mean, is that, you know, and it happens to be during early voting. I mean, are they going to end up in violation of the 75-foot rule? So just another thing to consider. Again, I mean, my goal here is not to just pick out issues with the bill. It's like we should address these items in a way so we don't inadvertently capture activity that we don't mean to, and that if we're going to draft a bill to do early voting, it should be the best bill possible. Section 2 has to do with effectively the expansion of election day registration, because now forgive me, I'm just catching up on some of this stuff. Early voting ballots and same day elections received by the municipal president. This is the delivery of the thing. I made a note about the timeline here, and I don't know why, but maybe it'll come back to me at some point. Moving forward, I'm in section 3 now, the last section. It says no elector shall be permitted to cast such elector's vote after the hour prescribed unless that person is in line at the prescribed hour. So we've taken our you're in line at 8 p.m. on election day law that was passed in recent years, and now we've added it to this entire period. So I guess that means that on the days where voting ends at 6 p.m., as long as you were in line at 6 p.m. and on the days where it's 8 p.m., as long as you're in line at 8 p.m. I guess my question is, what do we do about the staff involved? Are we going to require that the poll working staff and everybody stays until the last vote is cast as well? It certainly seems that way to me. I won't even pose the question. It's a consideration that I think we need to keep in mind. The next section has to do with the implementation of this policy, and it looks to me from this section, and confirm me, I tried to do all this very quickly earlier, so I just want to make sure I'm getting this right. It looks like this policy of early voting, at least in this bill, the Secretary of State's 1057, that it will not affect the municipal primary in 2023, but it will be in effect for the general election this year. Is that correct?
Yes, that is correct. And it's the same for all 3 bills. The purpose behind that is that the municipal primaries this year were judged to be too close to the current time to give officials adequate time to prepare. And we're intending for the first usage of early voting in Connecticut to be in the general election, the municipal elections this year, because the number of voters this year is anticipated to be lower than the number of voters next year, which is the presidential election. And we want to ensure that all the officials involved have an opportunity to run through all of these procedures on a smaller population to essentially work out the kinks so that we can fix any gaps or problems that we recognize next year in anticipation of that presidential election in 2024.
Thank you, Mr. Chairman. I appreciate that. One other thing that just occurred to me, just looking at, some of these dates on the timeline, and it's coming back to me that my note that I made in the previous section, which is that I think you're kind of closing up the timeline in some respects, because what we're doing effectively is by moving the beginning of the election process earlier, as much as 14 days. We're closing the window of time between the primary and the general election. And I guess the one thing that concerns me about that really is like CEP candidates, their ability to raise money after a primary and be able to file and be able to get their funds and still have time to expend those funds to run a campaign. I haven't done the math to figure out the exact number of days in that timeline process, but I think it's worth considering that I think it is going to change pretty dramatically. Just moving on, lines 250 through 252 is the section that effectively says that election day registration now applies throughout the entire early voting process. So effectively you have election day registration. The current law, I believe, says you can register to vote up to 7 days prior to election day. And of course, you can register to vote on election day via election day registration. And this changes that so that it will be that entire period. So the 10 days or 14 days prior to election day, but it will also, I think it does move the time frame where the election registration ends normally. And I'll have to get to that section of the bill. Mr. Chairman, can you speak to that quickly, how that changes? If not, I'm going to get to it at some point, so I'll leave it to you.
So I can address the kind of the policy decision why same day registration was extended to early vote locations and times. We wanted people, just like they are currently on election day, to be able to go to the polls, and if they are not already registered, to register and vote in one instance rather than having to come back again and again. And I guess with your more specific question, I'll look forward to when we reach that point in the text.
Okay, sounds good. Thank you. I think it's in section 23. I was just looking at it, but I have some more questions on that whole subject matter, so we'll get there. Just going through, I mean, you see all the time changes. There's a lot of conforming language here, just moving up the dates. At some point, I would love to have some kind of chart or graph that kind of lays it out for us on a calendar to get an idea of actually what's happening at what point in the calendar, because there are a lot of dates where candidates are required to file, where the ballots have to be produced, where the last day a candidate can end up on a ballot or can be removed from a ballot. All of these things have to be taken into consideration. And I know that there is an attempt to conform with the election day early period in this language. I feel more comfortable knowing that we looked at it hard enough to know that we got it right, I guess is what I would say. Section 6 and 7 are about public notice. Section 8 is about the certification of ballots. 9, it looks conforming. I was very confused at the end of section 11 about this language, about removing candidates, which I know I just mentioned, but I now understand what was doing. But this is an instance of conforming language. And I see that there were 2 separate sections, one to deal with 2023 and then one going forward. Forgive me while I skip through these sections that are conforming to get to something of substance. I noticed section 19, I guess, is the language that starts off talking about the Secretary of State's responsibilities to develop and conduct a statewide public awareness campaign to educate the public regarding the availability of early voting at regular elections and primaries. It also says in subsection B that the Secretary of State shall develop a early voting procedures manual. I don't know if that one manual will suffice or whether or not there needs to be one for the general election for state candidates and one for municipal candidates, because I think there are enough differences in the timelines and so forth that it might make it easier to have 2 separate manuals. This is fine. Obviously, it's going to generate a cost to the state of Connecticut for both of these things. There's some concern about the ability of a sitting Secretary of the State, regardless of who that is, at some point in the future to be able to use this for some type of self-promotion. But I don't see that is a real concern. I think that there should be some timeline in this couple of sections for when the Secretary of State is going to be responsible to produce and provide these things. And I don't see that specified in these sections. Section 20, 21, 22, all conforming. Section 23 is that piece about when the last day to register to vote is. So currently you can register to vote up until 7 days before an election and then on election day via election day registration. And this changes that to 14 days prior to an election. But of course, you'll be able to election day register 11 days before the election because that is the early voting period. So really what we're doing is we're narrowing that down to only 3 days. And I think that the reason why we have the 7 days in our law currently is because what we're trying to do is establish a uniform and clear voter roll of who's registered to vote near to election day that can be relied on universally. And if you've got people registering at the last minute and, who's working off what list kind of thing. And I get that. And I'm certainly agree that that's probably necessary. I just curious if narrowing that 7 days before one election day to the 3 days prior to 10 election days, or what happens in the other bills, I don't even know. I'd have to go back and look and see what the time frame is, but something obviously that needs to be addressed to make sure that we do leave that proper window. If you have, Mr. Chairman, if you know how it's addressed in the other two bills, I'd appreciate that.
Yes. So to answer your question about the other two bills, these days would just be changed by the numbers of days difference. So it would just be 4 days earlier. Essentially, it'll provide the same period.
Right. So it would be the 18th day prior to election. That makes sense. But we'd be left with the same situation, which is a very narrow amount of time that you could not register, which is probably a good thing. But is it enough time to accommodate the requirement to get one solid voter roll list? Okay. Looks like more changes that are just conforming in 24 and 25. I guess that's really all I had on the bill language itself. Just to bring us back to the beginning of the conversation, and you can see, I mean, I think that the bill's a lot more extensive than I had originally anticipated, and I think that's a good thing. I think that the folks that have been working on this have tried to come up with a appropriate policy for each conceivable question and concern that could come up. But as you can see, I'm just one set of eyes. I think that if other people start to go through this bill the way I did, they might find other things that are worth looking at. So hopefully we can correct them and get this as correct as possible on the first shot, and trying to work out as many kinks as we can before we're even doing that in practice. Just a question that I thought of while we were going through this, which is the notion of the process being very similar to someone coming into the town hall and saying they want to vote early. How does the town clerk make a determination whether or not that person should be early voting or casting an absentee ballot in person?
Thank you. So under the current law, you have to have one of the 6 reasons for obtaining an absentee ballot that are laid out in our state constitution and also in our state statutes in order to obtain an absentee ballot. However, under early voting, you wouldn't have to give any reason. Ultimately, the process would be pretty similar because you'd be showing up in person and you would be entitled to vote early by early vote in-person ballot, regardless of the circumstance. I don't think that the personnel operating the voting location would have to ask you any questions at all if you indicated you just want to vote. The person could say, do you want to vote here or do you want to vote absentee? And then if they want to vote there, they vote early via early voting in person. And if they, for whatever reason, want to take home an absentee ballot, they would then have to give one of the reasons that are listed by statute.
Thank you, Mr. Chairman. Yeah, so effectively, I get your response, and it's very thorough, and I agree that it is completely accurate. I mean, as I had pointed out earlier, everyone can answer with the response illness, and therefore, effectively, there is no excuse for absentee voting required. But leave that as it may. Does it really? I guess it goes back to my Monday question is really the thing, which is that if you show up on the Monday and you say, I want to early vote, is it the expectation of this policy that's before us that they'll be turned away, told them to come back tomorrow, or they'll be offered an absentee ballot? What's likely to happen on that Monday where early voting is not in effect?
Thank you. So my understanding would be that in that situation, the person would have the opportunity to request an absentee ballot. However, they would have to affirm under penalty of false statement that one of those reasons prevents them from voting in person. And I guess I take the senator's point about the capacious nature of the illness reason, but the limiting factor in that reason is the voters' affirmation that illness will prevent them from voting ordinarily on election day. So obviously there are a variety of illnesses, whether it's that person's or someone else's, that could qualify. But the person is limited in that they must affirm that whatever the illness is, it will prevent them from voting in the ordinary in-person fashion on election day.
Thank you very much for that response, Mr. Chairman. And not to turn this into a debate on that subject, I just would say that I wish that many of both of our colleagues during the last election took that view because they didn't. In fact, there were TV ads galore from very high-ranking candidates, actually, some elected and some not, who made it quite clear that anyone could get an absentee ballot just by asking. And they did that in TV ads, radio ads, mailed correspondence, et cetera, and then went so far as to provide them with ballot applications without any indication that they had any illness related to them whatsoever. And that's the problem that I see with that. So again, that's not necessarily relevant to this exact topic, but it's all relevant because, you know, my issue with all of this is that in the zeal to expand so many different avenues for voting, I think we've made what is somewhat confusing out of the situation, and it's very duplicative. I mean, an argument can be made that we have early voting right now. I mean, the fact of the matter is that I just made the argument that we already have no excuse absentee voting. And while I appreciate your comments and your distinction between whether someone could be eligible versus them actually stating that they're eligible, the fact of the matter is that we witnessed how it works in practice, which is the fact that everyone is eligible and they're encouraged to participate in that way by campaigns and candidates. And because that situation exists, you effectively have early voting in person or by mail as early as maybe certainly 30 days before election, but maybe before that. I don't know exactly when they print the absentee ballot applications. So there's that. And then early voting is simply going to be another mechanism where many people will do virtually the same thing. They'll walk into the town hall and ask to vote. I guess the distinction is not really clear for me. And if it's not really clear for me, I can imagine how vague it might be for a voter who is not thoroughly perused our voting laws in the state or been paying close attention as we've made these changes in recent years. And to me, what I would like to see is us, come up with a clear process. For me, we would go back to having the most legitimate version of absentee voting that has existed in the past, which is 5 days, and the illness has to apply to you directly. And we're not going to be as concerned about expanding it because we're already expanding early voting 10 or 14 days. You don't need to go through all that. But that's neither here nor there. And I don't foresee that there's a desire on the part of the majority to go back and limit the absentee voting. And my proof is the fact that we're still looking at a constitutional amendment for something that I believe we have in effect already. So I think that I've covered kind of what my concerns about the way we're headed on election law in the state as it is, which is that you'll get no argument from me or any of my Republican colleagues, and I think I can speak for them in this way by saying that we're all very much in favor of expanding access to voting. No one wants to prevent anyone from voting unless they should be prevented by virtue of, criminal activity or ineligibility in some way. In every other aspect, we are on the same page, which is to say, we want to encourage people to take an important role in preserving our electoral system and our form of representative government, which is so important to maintaining the system of laws and justice that we have in this country. So the issue really boils down to not access, but it is, are we preserving the integrity of elections in the process? And this is where I always say we fall short, because the fact of the matter is we fall short. I have a number of amendments, Mr. Chairman. I did tell your co-chair that I would wait until she was back on Zoom before I would call those amendments. And so if she is, I will begin. Alternatively, I could let other members of the committee speak to the bill first and maybe offer the amendments at the end. I would give you that option, and you can let me know how you want me to proceed.